That's for sure, and that's what they've been having.
Live from the Glasgow Electric Plant Board, Glasgow Wants to Know. With your host, Mr. Uhel Barrickman.
Good evening. Our subject for this evening is sexual harassment. It is a timely subject which has been brought to the forefront within the last few months and weeks, particularly by the Thomas hearing and also the trial of Kennedy in Florida. We have as our panel tonight Mona Goodman, who is an instructional program coordinator at the Glasgow Independent School System, Sallie Shirley, who is a teller at the New Farmers National Bank and has had some experience on a talk program as she appeared on the Oprah Winfrey show some weeks or months ago, and Steve Rhindhart, who is the Human Resources Manager of the Kentucky Division of R.R. Donnelly and Sons Company. This is a very broad subject and it means different things to different people. And my first question is going to be, what is sexual harassment? And I'm going to ask Mona to start.
It is a broad issue, Uhel. I think that there's certainly some legal definitions, but when we think of harassment of any kind, we think of something that is unwelcome to the individual that is on the receiving end of it. In sexual harassment incidents, it's something that the person perceives as being unwelcome or inappropriate behavior of some type of sexual nature. It can be anything as simple as a pat on the back, if someone perceives that as being inappropriate, or something much more explicit involving sexual favors or requests for such.
Sallie, would you like to add to that, or do you agree with what she said?
Yes, I do agree with what she said. A lot of times, I don't think people mean to harass you. It's just that the people take it the wrong way. That's about all I have to say.
And Mr. Rhindhart, do you want to elaborate a little bit on the technical or the legal aspect of it? I'm sure that with your position with R.R. Donnelly, you are acquainted with the legal aspects of it.
Well, I wouldn't claim to be a lawyer, but we obviously have to be sensitive to the legal implications of sexual harassment as an employer, in part because the employer it shares some liability in cases where sexual harassment is alleged or proven. And so there are some legal penalties that fall to the feet of the employer in cases like that. The only thing I would add to the definition would be to re-emphasize what was said earlier about the inappropriateness of the activity as being a part of the definition of what makes a particular action harassment, not only unwelcome but inappropriate. For us, I think as an employer, that area becomes very important because I'd like to think anyway, people show up for work to do their jobs, perform the tasks that they're paid to do, and focus their attention on that. And clearly when you start bringing in other activities that are inappropriate or inconsistent with that work task, then it becomes a particular concern to employers because it's clearly inappropriate for the workplace. Not that it's appropriate anywhere else, but especially inappropriate at work.
How widespread is it? Who wants to tackle that one?
I think it's probably more widespread than we were aware of. I think your opening statement regarding the Thomas hearings pointed out that much of the nation is not aware that this is a problem. But since that time, there has been a great deal of publicity and a great deal of people coming forward and saying that it has been a problem for them in the workplace. So apparently it's a fairly widespread issue. I think it's an issue that involves people of all ages, people certainly of all races, both sexes. We tend to think of it perhaps as something that happens to women, but I think that it's an issue that involves both sexes in some cases. Certainly it's not limited by age or even physical appearance. I think it's very widespread.
Is it confined to the workplace? Have you observed it any place or experienced it any place, Sally, other than the workplace or in the workplace?
It can be anywhere. It can be on your job or somewhere that you're doing your grocery shopping. It can happen to you anywhere, really.
Have you experienced it publicly in Glasgow?
I have publicly a long time ago, not lately. It's been many years ago, in the 60s.
And at that time, there was little said or done about it, and even less recognized than today.
That's right. What I did, I told my supervisor about it and let them see what was going on, and then they put a stop to it. That's what I did.
So it occurred in the workplace?
Yes.
I think it also occurs in situations where you have individuals dating. Wasn't really aware that this happened a lot with teenagers, but since, again, that it's been such a national issue lately, I have talked with some of the teenage girls, and again, I'm not just emphasizing the female, but that happens to be who I've talked with, and they say it happens in the dating arena, that it's a fairly common occurrence. It's part of the pressure, part of the peer pressure, if you would, within the dating situation of American teenagers.
I'd like to remind the audience that if you have questions for any of the panel members, call 651-8341 and we will try to get you an answer to the best of our ability. Again, the number is 651-8341. We welcome calls from you. And surely those of you out there who are listening have some questions about this, because it is a subject that means different things to different people. And yet it is an important subject, and one for which you can become liable in penalties if you violate certain aspects of the discrimination laws that deal with sexual harassment. And you notice I said harassment that time. I reverted to my earlier training. That's what I used to call such things, and now I understand the either pronunciation is correct, harassment or harassment. So I'm talking about the same thing, although I may interchange the way I pronounce it from time to time. Speaking of the younger people and those that are dating and so forth, where is the line? Sometimes there are indications, I would assume, where one party or the other would think that such conduct or certain conduct is invited, when actually it isn't. How can you tell the difference? Anybody want to tackle that one?
I think the main way you tell the difference, whether it's a dating situation or a work situation, is the person on the receiving end. If that person feels that it's unwelcome or inappropriate, then it's their responsibility really to speak up and say so. Particularly from a work situation point of view, that's really what we try to emphasize to employees, is that they have an obligation really to let it be known to the individual who has made a social advance, or whatever term you want to put to it, but has made an overture. If an individual feels that it's unwelcome or inappropriate, it's really their responsibility to say so. I think that would translate to a dating situation as well, that it's really the individual on the receiving end who bears a significant responsibility to speak up and say so. You can't do anything about it until the parameters, I guess, have kind of been laid out, and you've defined it as being inappropriate or unwelcome.
I think that is an excellent answer, and now I'm going to get back to Mona. What has peer pressure got to do with a response as to what one thinks is appropriate and what isn't?
The mention of peer pressure had to do with the commonness of sexuality among our young teenagers, and the fact that some of them, when they perhaps wish to resist being sexually active at an early age, feel that there is a inherent peer pressure in society today to be sexually active. It didn't really have to do with the controlling of the situation as much as it did the attitudes of society. To follow up on something Steve said there, and I agree with what you said, I think it's also incumbent on the individual that feels the harassment to act quickly, to make it known very quickly that the actions are not felt appropriate, that it doesn't seem to be something that you want to have continued, and to act very quickly. We probably in the past, and I'm going back to the time when I was in college and perhaps in the early professional days, at one point in time we probably told people, well, just laugh it off or try to make a joke out of it or ignore it, or perhaps it will go away. I think we've seen with some of the recent emphasis on this area in society that that would not be an appropriate thing to advise anyone to do now, but to very quickly make it known that you felt that it was an inappropriate advance.
Do you have, or is it possible that we have some problems in society now, again getting back to this peer pressure point, because I think that is important in what's going on in many areas today, not only sex but other areas. Is it possible and probable that oftentimes you have the peer pressure from the standpoint of the peers, and yet they go home and have pressure from the parents that is exactly contrary to that? And does not that leave a very confusing situation as to what is and what isn't, in so far as one knowing what to consider in his or her activities?
Yes, I think so. I think probably the most pressured and confused individual in American society today is the teenager. And not because they're not bright and capable individuals, but simply because they hear from many different directions some very confusing messages. On this area, I noticed that Dan Rather was interviewed by Arsenio Hall. And he said on that particular program that this was sort of an issue that had raised the American consciousness. And they debated long about the media aspects of it. You mentioned the Thomas hearings and the role of Professor Hill. And the very fact that all of that was played so openly on American television presented questions for not just American teens, but all of us in American society.
Well, that raises an interesting question. Was it good or bad, the media coverage, from the standpoint of the young people and from the standpoint of society as a whole?
Well, at the risk of being shut off the television immediately, I think perhaps there are more things on television than we sometimes need to see, at least to the depth that it's covered. You vary back and forth between the right to know and the right to privacy. Certainly neither Judge Thomas nor Professor Hill had any privacy maintained as the hearings continued, and I certainly do not have any idea and would not attempt to decide which of them told the truth, if either did. But the media many times, I think, escalates a situation, and in doing so, perhaps it does raise the American consciousness to an issue, but perhaps it also presents things on television that we wouldn't want all of our children to see.
On that same line, though, I think Thomas hearings served a purpose in that it did force a lot of people who would just as soon not acknowledge that the issue exists. It forced them to do just that, to acknowledge that there is an issue out there. It does take place. It's a lot more prevalent than we want to admit to, or that we would like to think is true, and did force people to come to grips with it, at least to acknowledge in their own minds, yeah, this is something that's going on. I tend to agree that perhaps we got too wrapped up in the personal life of the people involved, but the issue itself, I think, was healthy to have been brought out and in effect put on the table, brought out into the light of day where folks have to deal with it. And in a lot of ways, in a much smaller, probably on a much smaller scale, what we're doing tonight is the same sort of thing. We're part of the media in this particular setting, and hopefully, I doubt that we'll draw quite the same audience that the Thomas hearings had, but still the point is there may be somebody out there who, as a result of our discussion, has their awareness broadened a bit, or it's brought to their attention that this is an issue that they may have to deal with or do deal with, and may gain some benefit from the process. So yeah, I think the media sometimes goes too far, but in this particular case, it was good to at least get the issue out in the open and not pretend that it doesn't exist.
We have talked about the perception of the, for lack of a better term, victim. Now, I think that, or can we agree, maybe I better ask this question first. Can we agree that oftentimes men and women have different perceptions of what constitutes sexual harassment?
Can we agree that we have different views?
Yes.
I think I can agree that we probably have different views, yes.
Yes.
Mm-hmm.
Now, with that answered, what about the perspective of the person that is actually abusing somebody based on the perception of the individual that thinks that he or she is a victim? Are we going to ignore the perception of the perpetrator and rely entirely on the perception of the victim?
No, I don't think we can do that, and I don't think we have. I think we saw evidence of that in the media as we went through the situation with the Thomas hearings. Certainly, I think there's a difference in how all of us perceive things that are happening to us. We're never on the same plane at any one given time. But the great danger, perhaps, in this is that there could be almost a overreaction, and that the perpetrator, which always sounds like they're guilty when you use that term, maybe there's some other term we could use. Assailant doesn't sound any better.
It doesn't sound any better. We're both having difficulty with
the person involved on the side of perhaps doing the harassing may not see it as such. If they do not, I think probably then they respond very quickly when an individual tells them that they don't consider this appropriate. I think that would be the kind of individual who would stop what they were doing if they were told, it bothers me for you to pat me on the back, or it bothers me for you to call me honey, or it bothers me for you to refer to me as a sugar or sweet thing during professional meetings. That would be the kind of individual that I think would very quickly stop their behavior.
What about somebody that refers to you in those terminologies not in a professional meeting or not on the job? Are they guilty also of harassing you?
Well, you're the attorney. Legally, probably not. You're saying, can this occur in a social sense, a public sense? Yes, it can occur. Sally, you were talking about that earlier.
It can occur because I don't think people, think about it sometimes. Maybe they pat you on the back or hug you or say honey or whatever, I don't think they realize that it may bother someone. Sometimes it might bother that individual, and sometimes it may not. You know, it's just according to how you feel about it.
Well, does oftentimes that depend on who is doing it?
That's true. That's true. Sometimes you're glad that that person is harassing you, if you like that person, if you want to call it that. And if you don't like that person, you may use that excuse that you harass me if you don't like that person for some reason or other.
Now there again, how is the person that is the perpetrator, and again, for lack of a better word, how is he or she going to know what to do in that situation?
I think a big part of it is, getting back to what we were talking about before with the media, I think a big part of it is making people aware of the impact of their behavior on others and how it's perceived by others. Perception, how I perceive the world is pretty hard to get a handle on until I get more information from others that I can then compare my perception against. And I think that's what I was getting at earlier with the comment on the media, that by talking about the subject and getting to hear different perspectives from different people, we can then lay that alongside our own perceptions and better understand, hopefully, how different people do perceive things in different ways. One of the things that as an employer that's incumbent upon us along those lines is the responsibility to make employees aware of what the definitions of harassment are, what unwelcome social behavior is in the workplace, so that their perception can be compared against what our definitions as an employer of acceptable behavior are. And therefore they're on more firm ground. They don't have to guess, well, if I do this, is this going to be perceived as improper? They have the definitions up front. So as an employer, one of our responsibilities is to communicate that. Let people know that this is our policy and these are the kinds of things that, according to that, are considered inappropriate. And these are the kinds of reactions that are going to occur when those behaviors are manifested in the workplace.
Well, I know that, or at least I'm sure, that you have policies concerning it in your company. Any company, even the smaller outfits. I'm satisfied also the Farmers Bank's got such a policy, and I would assume the school has got a policy concerning it. Now, how do you make your employees aware of those policies? I gather from what you've just said that you do, but how do you go about that?
A lot of different ways. Something as simple as posting on public bulletin boards within the plant, so that areas where information of general interest to employees or announcements related to company business, that's another aspect of how the company does business. And in our case, we say the company has a policy that makes sexual harassment unwelcome at work, and we post that along with that. We've also included it in newsletters that are distributed not only within the plant but even mailed to employees' homes on occasion. So that information gets into the employee's home as well as being given to them at work. And then we cover it in a variety of other areas, in various kinds of training events for supervisors on things that are part of their responsibility as a supervisor or manager, or with employees that have responsible positions where they're functioning as a crew leader or in charge of the activities of other employees. We want to make them aware that in that position of responsibility, they have a responsibility to carry out company policies. So we try to communicate in a lot of different ways.
We have a question. It says, what about the philosophy of innocent until proven guilty? In these situations, the accused seems to always be assumed guilty until proven innocent. Anyone care to comment about that?
I think that's a good question, because always, when someone accuses you of something, the accuser's not always the one. That person may be angry with that person for some reason or another and trying to find some reason to cause problems for that person. That could happen. And it's not fair to judge that person until you are sure, you know, without a doubt, that he or she has did that.
I think what we saw nationally with, again, the Thomas hearings, and then you made a reference to the Smith trial, and I believe that was held in Florida.
Right.
In both cases, there was an enormous amount of attention focused on the aggressor. Is that better than perpetrator? And in both cases, the individual was determined to be innocent. Now, of course, Judge Thomas, it was not a trial to determine innocence, but the Senate determined he deserved a seat on the highest court in the land, which I think affirmed what they felt, at least, was the factual nature of the case. And in the Smith trial, the accused was found innocent. So I think perhaps that the danger is in someone, as Sallie said, becoming angry and accusing someone falsely. But optimistically, I think that in most cases the truth wins the day.
The second part of the question is, how can we convict people of crimes with no witnesses, no evidence, only hearsay? I can say from the standpoint of a lawyer that opens up quite a can of worms, because certain types of hearsay evidence is permissible and can be used as substantive evidence for conviction. However, you've got some kind of witnesses in that situation. So I really don't know how to answer that part of the question, and if any one of you three want to comment about it, why, I'd be glad to hear it.
The only observation I would make is that in a case where an individual is making an allegation that he or she was sexually harassed, that's not hearsay. That's that person relating their experience. That's firsthand testimony, if you want to put it into legal terms. So it's not really hearsay. The difficulty that the Senate came into in the hearings with Thomas was two different people saying two different things happened, or one saying it happened and the other saying it didn't, and you had to make a judgment based on the assertions of two different people. But it really wasn't hearsay. It was differing testimony, different perceptions perhaps of the same events that was really at stake. So I'm not sure in cases of trying to make a determination of whether or not sexual harassment occurred, it's always so much an issue of hearsay as it is trying to make some sort of come to some sort of conclusion on two totally different points of view or perceptions, and there I guess the veracity of the people involved comes into play.
Credibility
Exactly.
has the most important part to play there. I think the thing that was most lacking in the Thomas hearing was the lack of good cross-examination of both now Justice Thomas and Mrs. Hill. I don't think either one of them were adequately cross-examined. I think that for whatever my opinion may be worth, but I think that the Senate committee should have employed practicing trial lawyers to have conducted the hearings, and then you would have had cross-examination. I would have delighted to cross-examine either one of them, and I don't think either one of them were cross-examined very thoroughly. But now we're on another point. How successful do you think you are being in conveying your message at Donnelly's about what sexual harassment is, and what reaction are you getting from your employees, if any?
Good question. I don't know how we gauge how successfully we're conveying the message. It's like communicating anything. You can say the words, you can show the written documents, you can do any number of things like that that demonstrate that the message is being conveyed. You don't always know whether it's being received, so that's always a dilemma. I don't know. I don't have a real easy answer for how you determine whether your message is getting across or not. I guess there are a couple of ways to look at it. One would be if the number of incidents, excuse me, if the number of incidents or complaints increases, you might say, well, people are more aware, therefore they're more vocal and they're coming forward. On the other hand, you could say, well, if the number of incidents goes down, then you're doing a good job of educating people, and therefore things are not happening that would have otherwise happened. So I don't know. If it stays the same, maybe you've made some headway, and maybe you haven't. I don't have a good answer for how you gauge whether you're getting the message across or not. You just keep trying, I guess, and reinforcing it.
I will understand if you don't care to answer one way or the other.
Mm-hmm.
But are you having more or fewer or about the same complaints, same number?
I don't think it's much difference one way or the other. That's my experience anyway. So I don't see a big change one way or the other. There's probably more talk about it, and clearly as a result of the Thomas hearings, I think there was more discussion and talk among employees and various groups within our business or any other. More discussion of it and more awareness of it. Whether that translates into more or fewer complaints, I don't see it as being a big difference myself.
I'd really like to make some comments there about the complaint process. And we have all said that we feel it's very important that the individual that feels like they're a victim complain, first of all, to the aggressor and try to settle it at that level. I think the reason that we can't judge whether or not we're being successful by the number of complaints is that there are so many people who fear the complaint process. And if the only place in which the harassment issue can really have a major impact on you is if someone has power over you. And if that's in the role of a supervisor, a manager, a superior in some way, and you fear that this would impact on your job and therefore your livelihood and your ability to maintain an income for your family, or you fear that this would prevent you from having better jobs offered to you, promotions and that sort of thing, I think many times people do not complain through the process that's very good that a company may have, a policy process. But they fail to use that process because they fear retribution. They fear not being believed, and they fear that the person who is the aggressor, who is the harasser, has more power than they have, and therefore that their complaints will be minimized.
But that is the exact type of harassment that the law does cover and provides a remedy. And they can always, and there are more and more actions being filed based on incidents similar to that. You can always file an action against the perpetrator and the employer. And many times the employer is not responsible, but the perpetrator is. But there are also incidents where the employer can be responsible legally as well as the perpetrator. And the law is rather clear on that insofar as workplaces are concerned, and I think businesses generally should become more aware of the law. And we may discuss a little more about that later, but in the meantime, let's get back to the schools policy. How is that being disseminated, and what reaction are you getting in the school system?
Well, as far as policy, what the school board has is a broad statement against any form of discrimination related to race or sex or anything else, and certainly this would come under that general area. To my knowledge, it's not been a major problem within the school system, and we've not seen any increase in the number of complaints or anything of that nature.
Has there been any efforts made to disseminate any information on this particular subject to the employees of the system?
I don't think anything has been disseminated any different from what we've had in the past.
What about the bank?
As far as I know, we haven't had any problems.
But there is a policy out there
We
also.
have a policy, and it tells you about harassment, and everybody is familiar with it.
It's in the manual, a policy
Right.
manual,
It's
I
in the
presume.
manual.
Is that correct?
And every employee has one.
And I would assume you probably, that's another way that you convey the policy at Donnelly's. Do you have a policy manual that each employee gets, and that's in that?
Well, we utilize an employee relations manual. It has all the company employee-related policies in it, and they're positioned in various places around the plant, so they're openly accessible to all employees, but we don't give everybody physically a copy of it because of the things change, and it's with 2,000 employees just in Kentucky and 26,000 nationwide, it's be a pretty big job rewriting and reprinting all the time to keep it updated. It's much easier to do with a centrally accessible manual that we keep updated, and it's available to any employee, and they can look up not only the company's policy on sexual harassment, but anything else. But yes, a long answer to your question. We try to get it in their hands in one way or another, primarily by making it accessible.
You have many situations today where you have people of both genders working for the same employer, and oftentimes it becomes necessary as a part of the business for people of opposite gender to travel to some location for business purposes or to attend seminars or things of that nature. So I'm going to raise a few possible scenarios here and see what you all think as to whether under one situation there has been sexual harassment or not, and vice versa. But let's assume that you have a gentleman and a lady that are sent to a town for business purposes of some kind. They check into a motel. We'll say in this instance that the man is the lady's superior, and it comes after the day's work. They're both going to be there overnight. The man invites her to go to dinner with him. They go to dinner and have a glass of wine along with the meal and so forth. And then there is a suggestion by one or the other that they go see a movie. And the movie, as many of them are these days, have quite a bit of sexual content in it. And afterwards, when they go back to the hotel, the man invites her in for a nightcap, and she refuses. Has there been any sexual harassment on the part of either party?
Up to that point, I'd say no. In large part, where it goes from there may determine whether or not there's a claim of sexual harassment. But at this point, based on your discussion anyway, no one has asked or requested any sort of sexual favor in response for or as a condition of employment or promotion or any other aspect of work. It's two people who know each other and happen to be in the same town at the same time together. So I don't see anything up to that point.
Now let's add this to it. Let's suppose that during the dinner that they had, that the subject of a promotion for the lady came up. And then we had the same scenario. Does that change the situation any?
It shouldn't. She shouldn't go in his room.
Well, she doesn't, but he invites her.
Oh.
But she doesn't. But he invites her in for a nightcap. But she does not go into the room. But there has been a discussion of a possible promotion during the dinner. Does that change the situation any?
I don't think any harassment has occurred there yet, although I think probably she will recall that during the same evening she was invited in for a nightcap and a promotion was discussed. Most employees would remember that those two things occurred on the same evening.
We have another question, and again I invite the audience to send in questions. Surely there are a lot of questions out there, and this is only the second one we have received. Again, the number is 651-8341, and we would appreciate any questions that you may have. We would also appreciate any suggestions that you may have for a topic for future programs of Glasgow Wants to Know. Again, surely you have topics out there on your minds that you would like to hear some discussion of by people in Glasgow. So if you have any suggestions along that line, call the plant board at 651-8341 at any time. This question is, does every employer need to have a policy manual that covers stuff like this? What about just telling employees they are to exercise sound judgment at all times? Would that pass muster in your firm?
Probably not, and the main reason I say that is that to protect themselves from the legal liability that exists, the employer probably needs to have something that's more readily available and easier to produce and as documentation that information has been conveyed. And I guess that comes out more of the litigious nature of our society these days. Having the policy is both proactive and also defensive for most employers. It's proactive in trying to prevent problems, but it's also a defensive posture if problems do arise, and being able to demonstrate that actions were taken up front and it can be proven because it's there in writing and you have proof that it was made available and employees were aware of it. So just to say, isn't it just enough to tell people to use good judgment as an employer, and you probably would agree as a lawyer, no, I don't think that's quite good enough. It's unfortunate, but it's probably not good enough.
I'd like to say that I don't think that it's not good enough either, because you need to have something written down. You can't beat having something written down on paper, and you can go have something to go by, so people won't have no excuse.
Mm-hmm.
I think that's a very good point.
Mm-hmm.
I agree, and I think it's also a good point for employers, whether they have written policies or not, and not all small businesses have policy manuals, just basically corporations or larger entities. But I think it's important for employees to know what their rights are, and that they have a right not to be sexually harassed on the job as a nature of their employment, and that should that occur, they have the right to document all cases of it, and certainly to report those cases to their superiors, and if necessary to take legal steps. But hopefully things can be reconciled before that. But I think it's very key that all of us as individuals know that we do have a right not to be sexually harassed.
I think the points are well made, and insofar as an employer who may get sued for permitting sexual harassment in his plant or firm or whatever it may be, and the only thing he has told his employees was to use sound judgment in such an action, that would not be a legal defense, and he would be hurting if that's the only defense that he has. Let's get back to the scenario again of the couple of opposite sexes going away on a business trip, which is perfectly legitimate. And again, it doesn't make any difference which one might have invited the other, but let's say again there was an invitation to go out to dinner together. And this time, the young lady dresses in very short dress that you see more and more of these days, and perhaps has on a see-through blouse with low neck, and they go to dinner. And again, then we have the same scenario that we had again, and come back and get ready to go to the hotel room, and she is invited in for a nightcap. But again, she refuses. Has there been any sexual harassment there?
I think so, because first of all, she shouldn't have dressed like that. If she was out on a business trip, she should dress in business attire, you know, clothes. She should have herself covered. She shouldn't be dressed that way. To me, that is harassment.
And the man, I take it from what you were saying, is being harassed in that situation.
I think so.
Now, it may not, you're not necessarily saying, I take it, that she would be legally responsible, because nothing has been said about jobs or anything else so far, but at least socially, I take it you're saying that he's being sexually harassed.
That's right. That's the way I feel.
I think I'd disagree a little bit. I don't think I'd use the word or the term harassment. I think she maybe is being less than professional in her relationship with a coworker in those situations. But if we want to stick to what harassment really is, there's been nothing that has interfered with either person's rights, opportunities, or whatever in terms of employment or compensation that would make it become harassment per se. I think it's unprofessional, perhaps, but not necessarily harassment.
Do you have any comment, Mona?
I agree with what Steve said. Of course, she always runs the risk she's going to run into someone from Glasgow or Barron County, and it's going to ruin her professional career anyway, so you're never too far from home.
That is very correct. We have another question. It says, what is each panel member's opinion of guilt or innocence of Justice Thomas and William Kennedy Smith? Now, we can't force any one of you to answer that question, but if you'd like to comment on it, I'm sure the audience would be delighted to have the answer.
I'll jump in there with both feet. I'll be the first to admit that I was probably apparently one of the few people in the country that didn't watch the Thomas hearings from gavel to gavel. I caught very little of it and read only brief accounts in the newspaper. I don't know. I don't really have an opinion in terms of his guilt. I'm not sure his guilt was an issue. There was concern over the appropriateness of his behavior for someone who was going to be a Supreme Court justice. But I don't have an opinion on that one. As far as the Kennedy Smith case, my opinion really doesn't matter. The jury said he was not guilty. So I leave it up to them. They're the ones who heard all the testimony. That may be, you may see that as a cop-out, but if that's the case, then I'm copping out. But the jury said he wasn't guilty. I have to go with that.
Very good answer. Sally, you care to comment?
I watched part of it. I'm not sure which one was right or which one was wrong, or if either one of them was wrong. But it could have been partly both of them's fault.
How about expanding on that a little bit?
Just say, for instance, you was talking about the clothes that the lady was wearing. Maybe when she worked for him, sometimes another, she could have been dressed like that, and maybe he said something to her, and maybe that's what she was talking about. It could have been something like that. I don't know.
There again, going back to what I said before, they weren't cross-examined very thoroughly. And that's one aspect they could have been cross-examined about, or she could have been, and there were many that he could have been and should have been cross-examined very thoroughly about, but wasn't. I understand where you're coming from, and I think you got a valid point.
That's right.
And again, nobody knows. Mona, you got anything to add?
Well, I won't be too wishy-washy about it. I thought probably Judge Thomas was guilty, at least up to a point. Now, whether or not the incidences were exactly related as they had occurred, certainly no one knows. But I felt there had to have been something occur in order for Professor Hill to have come forward and to have made the public spectacle of her life and Judge Thomas's life that it was. So I felt like there was some guilt involved there, and I will say that up front. As far as William Kennedy Smith, I did not really watch closely some of the coverage of that. I felt like it wasn't really a national issue. That was covered by the media simply because of the man's middle name, not because of any prominence that he has, particularly within world affairs, not because of any prominence that the individual had, but because of his middle name. As to whether or not he was guilty, the jury said that he was not, and they were there and listened to the testimony, so I really don't know how to call that one. But on Judge Thomas, I felt like there was probably some substantial reason for Professor Hill to make the charges.
Another question, do you think it was right to not show William Kennedy Smith's accuser on TV? Sally?
Well, I don't know why they didn't. It must have been a reason why they didn't. I don't know what it was. I don't know if they were trying to protect him from someone or what. I'm not sure.
Does that relate, Uhel, to privacy laws in some states related to rape victims?
It could, and I don't know what the privacy law in that regard
In that state
it was and is in Florida. It could have been that. It could also have been, I think, to encourage other people that were, or at least thought they were victims, or other people that thought they had been raped, to come forward so that their name and would not be disclosed so as to affect them later on after the trial was over.
Of course, her name was published in written media,
published
and
in
her
written
picture's been used since
media,
then.
and well, of course, she came out
Yes.
publicly afterwards, and
I really didn't feel like that trial belonged on television anyway.
well, I agree with that. I didn't think that the trial should have been that trial should have been on television, and I don't think it would have been on television except for the Kennedy connection, as you've already pointed out. I think that's the exact reason why it was on television. But
Well, the situation with Judge Thomas was different because he's a young man. He has a lifetime appointment now to the Supreme Court, and that did have national merit to at least know about it. Again, as I said earlier, I felt like we probably knew more than perhaps we needed to know from a televised media. But I didn't think that the Smith trial had any national merit.
On the other hand, getting back to the Kennedy trial and the matter of covering the face of the accuser, it was a public trial, and had you been down there and could have gotten in, you would have seen her. And there was no way that they attempted to or could have covered up her face while she was actually testifying, because that would have been deprivation of a constitutional right of being able to confront your accuser. And since it was a public trial, I'm inclined to think that it was not necessary to hide her face insofar as the legal aspects of the question is concerned. In order to protect her from public opinion and so forth, and public talk, it might have been necessary. And of course there was a big argument as to whether the paper should have disclosed her name in the first place. And that is a good question, again, not necessarily related with this subject. I'll give you the facts of an actual case very briefly here, and I think maybe the public should be aware of how these things can go. This was a case that arose in our neighboring state of Tennessee. And again, this is where I got a part of the scenario that I was raising here and changed some of the details. But in this particular case, was found guilty, a male superior was found guilty of sexually harassing a female employee during a business trip, even though the superior did not issue an invitation to the female employee to enter into any type of sexual relationships with him, and did not force one upon her. But he insisted that she come to his hotel room, provided her with wine, turned the television to sexually explicit movie, attempted to restrain her departure in the sense of trying to talk her out of it when she got ready to leave. And when she did leave, he slammed the door behind her very hard when she left, and he was convicted of sexual harassment. And that is now a reported case.
I would assume the provision or the portion or interpretation of sexual harassment that was part of that case was the one that most people don't focus on quite so much, which is the issue of hostile environment. We tend to think of sexual harassment cases as being quid pro quo, to use the legal terminology, of an exact trade of favors for consideration for promotion, or in order to prevent the withholding of that. The other that has gained more and more notoriety in recent years has been the hostile environment interpretation, where the workplace environment, even though there may not be an explicit request for favors or whatever, the environment that's created is one that is hostile to the individual, and therefore makes it very difficult to resist behavior, or is seen as being psychologically damaging to the individual. And that's the kind of situation I think the individual there was using.
You timed it perfectly. I was going to call attention to that very thing, and the case that holds about and created this business of an abusive working environment is a case from the western part of the United States, and it's Ellison versus Brady. And it requires that if there is a condition in the working environment that is conducive to any type of harassment based on gender toward either sex, that the employer has a responsibility of correcting that environment. And if he doesn't correct the environment and there is harassment, then the employer as well as the accused, if there has been valid legal harassment, is liable to the victim. And that's a very good point, and I don't think that employers generally are aware of that situation yet. And another important part of it, and I realize that our time is about up, the standard for determining whether or not there has been harassment is the sensible woman standard, whether or not the action would be offensive to a reasonable woman, an ordinary, reasonable woman, and that is the legal standard. I believe time is up. Thank you for listening.